Hello, I'm Ashley Winberg, an associate lawyer with the law firm of Elia Associates, which specializes in condominium law. In this web session, I'll be discussing recent changes to employment-related legislation, which impose new obligations on condominium corporations to protect their workers from workplace harassment and to ensure that any independent contractors retained by the corporations to perform construction work have registered with the Workplace Safety and Insurance Board. First, under the Occupational Health and Safety Act, condominium corporations are deemed to be employers, and as employers, they have a legal obligation to take proactive measures to protect their workers, including property management staff, from workplace harassment. Under the Occupational Health and Safety Act, workplace harassment is defined as when one engages in a course of conduct directed towards a worker or a group of workers that is known or ought to be known to be unwelcome. Although the unwelcome conduct must occur more than once, it can occur over a relatively short period of time, such as a few days, or over a relatively long period of time, such as a couple of years. Repeated offensive, intimidating, humiliating, and demeaning words or conduct directed towards a worker or a group of workers in a workplace constitutes workplace harassment. One example of workplace harassment in the context of condominium corporations is if an owner, over a number of weeks, engages in a course of conduct directed towards an on-site property manager, in which the owner engages in humiliating or demeaning words or actions directed towards the on-site property manager that are unwelcome. In such a scenario, the condominium corporation has an obligation to protect the on-site property manager from any other further instances of workplace harassment. In doing so, it may be reasonable for the condominium corporation to instruct its lawyer to send an enforcement letter addressed to the owner, advising the owner that their behavior or conduct constitutes workplace harassment and will not be tolerated by the corporation. It may also be reasonable for the corporation to instruct the owner that they must cease from contacting property management directly or must cease from entering the property management office at any time aside from an emergency situation. Recent changes to the Workplace Safety and Insurance Act now make it mandatory for independent contractors to also register with the Workplace Safety and Insurance Board. These legislative changes require that independent contractors, much like regular employees, register with the Workplace Safety and Insurance Board prior to the commencement of any construction work, and that independent contractors refrain from performing any construction work unless they have been issued a valid Workplace Safety and Insurance Board clearance certificate. The legislative changes also require that condominium corporations obtain a Workplace Safety and Insurance Board clearance certificate from any contractors retained to perform construction work on the property prior to the commencement of that work. And if a condominium corporation fails to do so, they may be fined for up to $100,000. Although these legislative changes discussed in this web seminar require that condominium corporations take proactive action to protect their workers from incidences of workplace harassment, and also to ensure that any contractors retained by the corporation are registered with the Workplace Safety and Insurance Board. If a corporation fails to do so, they not only run the risk of being fined by a provincial officer, but may also be held liable for any injuries or damages sustained if an employee is subjected to workplace harassment or if an independent contractor is injured while on the property. For more information on employment-related matters and other issues affecting condominiums, please visit the reading room at condocentric.ca.